Good Cahirlik, and I'd like to welcome you to the House, Minister McEntee, and join with others in congratulating you on your recent appointment and on your great work in your previous role. And to say that I'm glad to see 4 great women nominated as Cabinet Ministers, but I'm sorry there aren't more women in Cabinet. And indeed, in this incoming Seanad, we have 40% of our senators are women, and that's a notable high, and I'm very glad to see that. But we will keep, I think many of us will keep pressing to see greater participation of women in politics and greater recognition in terms of Cabinet, because we still have very poor numbers in terms of overall numbers of women having served in Cabinet. So to turn to the motions tonight, I know that, like many colleagues here, I've debated and spoken on various occasions in previous years on debates on these renewal motions. I'm pretty sure we have never debated the renewal motions so close to the renewal deadline. I think, Minister, we're 4 hours away from the time at which the provisions will cease to be in operation, to use the words in both acts. So we are treading very close to the deadline. I very much welcome the proposal by your predecessor that there would be a comprehensive review of security provisions and of these motions and of these provisions undertaken. I think that's very timely. I like Senator Ward. I have an attachment to the principle of jury trial, like most people who've practiced criminal law or know something about criminal law. And indeed, I practiced in the Special Criminal Court, so I know the way it operates. And it should be an exception. It is an exception in our system, in our constitutional system, under Article 38, under Article 38(3)(1. It is an exception to the due process guarantee in Article 38(1), because special courts under the Constitution may be established by law in cases where the ordinary courts are inadequate to secure the effective administration of justice and the preservation of public peace and order. And we do well to remember that when we're debating these motions every year, and indeed when the review is undertaken. And as Senator Higgins has said, this is a point that I made, and indeed my colleague in the Dáil, Deputy Sean Sherlock, made last year when we were debating these motions. And I just want to address that point and one other point as issues that I think need to be highlighted in the welcome review that is to be undertaken. So that first point, therefore, that where special courts are being established, in other words, where non-jury trial is being retained in respect of certain offences, as it is through the provisions that we're debating, through the renewal of these provisions, under which we see certain offences under the Offences Against the State Amendment Act and under the Criminal Justice Act being scheduled offences and therefore tried by the Special Court. In those circumstances, we need to see that the inadequacy of the ordinary courts, the jury courts, to administer justice must be determined in accordance with law. And indeed, this time last year, Deputy Sherlock put down amendments in the other House seeking to copper fasten that requirement to ensure that more information would be provided to us as legislators each year in the annual report as to why the government says that the ordinary courts are inadequate to administer justice. And, as every year we get these reports, I read them again this year, the reports we get disclose, in fact, very little information. They disclose basic numbers, Minister, as you've read out, as to the times each year in which various provisions have been used. So we hear, for example, that Section 2, the inference drawing section, was used on 11 occasions in the last 12 months since June 2019. The Section 7 offence 20 times. But a number of provisions were not used at all in the last 12 months, Sections 4, 6, 8, 12 and 17. And I remember last year a number of those sections hadn't been used in the previous 12 months either, Sections 6, 8, 12 and 17. That's in respect of the Offences Against the State Amendment Act. In respect of the Criminal Justice Act, again, we see a similar pattern. As you've said, Minister, there were 72 arrests in the last 12 months in respect of the offences under the 2009 Act. But some provisions were not used at all, notably Section 71A, which is the offence of directing the activities of a criminal organisation. So, there are certain patterns of usage and non-usage disclosed in the reports, but there's really no substantive information, or very little, as to why the government say the ordinary courts are inadequate to secure the administration of justice. And that's the specific point that was the subject of our amendment, where we sought last year to get to obtain further information on this from the government. And I know that last year Minister Flanagan rejected the amendment, saying that members will engage in their own research, consideration and knowledge, which will form their views as to the operation of normal courts and the capacity to administer justice, and the amendment was lost. I think the difficulty with Minister Flanagan's response is that certainly we as Oireachtas members must inform ourselves on points when we are debating motions every year. But it can be countered that much of the information that would be useful to us is primarily within the domain of the government and not within the domain of us as legislators. And there are alternatives, and certainly the FEMPI legislation required, for example, the laying of certain financial information before legislators when they were making decisions on renewal. So that's a point, Minister, that I would like to see taken on board in a comprehensive review, a point about the basis on which the government seeks to bring offences before non-jury courts. And the second point relates also to the information in the reports that we get each year, and this is the information about patterns of usage and non-usage. And I've already pointed out that some provisions are typically not used over the previous 12 months. And if one looks back over different years, one sees that certain offences or certain provisions are almost never relied upon by prosecutors, while others are very frequently. And I mean, that's also a fair point. And again, as legislators and whoever is conducting the review also should be looking at these patterns to see if, in fact, the retention of certain provisions in force for periods longer than 1 year should be considered. But conversely, where there's a clear pattern of non-usage of a provision over a number of years, then their repeal of such provisions should be considered. So, these provisions effectively are sunset clauses, but it does beg the question as to how useful are sunset clauses if there's very little scrutiny or very little substantive scrutiny each year, and should we instead be looking at a more considered approach to the specific provisions under review. So having said that, I am very glad to see the review being promised. I think that's very important. I think that it should consider the nature of the renewal procedure, and it should consider in particular the sort of information legislators should have if we're to continue having these sort of sunset clauses in place, and it should also consider I suppose the taking of more decisive action in respect of specific provisions where patterns of usage and non-usage are disclosed. So with those few points, I just want to say for the Labour Group, we won't be opposing the motions, Minister, but we do very much welcome the review, and we do very much want to ensure that there is substantive scrutiny in place over these provisions, particularly in light of the importance of the principle of jury trial. And I know the Irish Council for Civil Liberties and many other human rights bodies have made very robust calls for the abolition of the Special Criminal Court and for less frequent usage. So I think that also needs to be borne in mind in any review. Lastly, I just want to refer to something Senator Ward said about the personalised attack on members of the judiciary, and I would agree with Senator Ward. I don't think it's ever appropriate for members of the Oireachtas to make personalised attacks on judges. It's one thing to criticise a judgment and to be critical of the outcome of a court case, but it's quite another thing to make personalised attacks on judges, and I don't think that's appropriate in a democracy. So, Gur Mahagat, and welcome again, Minister, and congratulations again.